Chair. Good morning, Chief Coit. You've been the second in command of the APD as the Assistant Chief of Police for 2 years. Is that correct?
Yes, it is.
And in that role, you report directly to the Chief of Police?
Yes, I do.
I'd like to start by talking with you today about the APD work rules. I'm going to start by showing you what's been marked as Exhibit C3. Can you see that here on your screen?
Yes, I do.
This is the APD Standard Operating Procedures 2010, effective January 18th, 2019. Were these the work rules in effect in June of 2020?
Yes.
And moving forward to page 12, I'm going to show you on the screen Rule 4.2.5.0 regarding maltreatment or unnecessary force. Are you familiar with this work rule?
Yes, I am.
And can APD officers be terminated for violation of this rule?
Yes, they can.
And this rule 4.2.5.0 was in fact the work rule for which Appellant Rolfe was terminated. Is that correct?
I believe that is correct, yes.
Now, moving on to Mr. Rolfe's termination, I'd like to show you Exhibit C1, which is Mr. Rolfe's NPAA. Is that your signature on the document? We'll scroll down.
Yes, it is.
And the employee response session set here in the NPAA is June 13th, 2020 at 4:45 p.m. Is that correct?
Yes.
And were you at APD headquarters at that time set for the employee response session?
Yes, I was.
Okay, I'm going to show you Exhibit C2, Mr. Rolfe's NFAA. Is that your signature on this document as well?
Yes, it is.
And can you tell me why you signed and not former Chief Shields, whose name we see printed on the NPAA and NFAA?
I believe the reason that I signed, we were in various meetings and a lot of things were moving rather quickly. And so the document was given to me to sign because they wanted to move ahead with the process. So I signed the document.
And just to be clear, did Chief Shields herself ask you to take care of the signatures on the document?
Yes.
And the Chief of Police has the authority to terminate an officer, correct?
Yes, the chief has the authority to terminate an officer.
And whether termination is the appropriate level of discipline is in the discretion of the Chief of Police. Is that correct?
Yes, it is.
So when former Chief Shields told you to sign the NPAA and the NFAA, that was her decision to make at that time. Is that correct?
Yes.
And I'm sorry, I didn't mean to interrupt you.
No, I just said yes.
And that was her decision, you would say, regardless of whether you agreed with her decision. Is that right?
Yes, that is correct.
And at the time Chief Shields told you to sign the dismissal forms, had Interim Chief Bryant been appointed by the mayor yet?
To my knowledge, no.
So Chief Shields was still the Chief of Police?
Correct.
And when you signed Mr. Rolfe's NPAA and NFAA, you did agree that the chief was acting within her given authority under the code?
Yes.
Now, I heard you say you've been with APD for 29 years.
Correct.
Have you been a police officer any longer than that, or did you start your career at APD?
I started my career with the Atlanta Police Department.
Have you seen some of the video from the footage of this interaction with Mr. Brooks?
Yes, I did.
And putting aside for a moment how Mr. Rolfe handled Mr. Brooks, in your long and decorated experience as an officer, can you tell me what you would have done differently to handle Mr. Brooks so as to decrease the possibility or the probability of resorting to deadly force?
Well, it's always easy. First off, it's always easy to Monday morning quarterback because I was not in that situation. But initially, when it occurred, I believe that I would have tried to walk Mr. Brooks back to the vehicle, closer to the vehicle. So if he did try to run or fight, I would have been able to use the car as some type of barrier where I could have pushed him into the car instead of being in a wide open parking lot.
Anything else that you observed from watching the video?
As far as what I would have done differently,
Yes.
no, because I believe the officers acted accordingly. The officers were trying to show compassion. They were not overly aggressive. They tried to do everything they could to calm the situation down. So I don't think it's anything other than that I would have done initially when it started.
Now, one of the 3 bullets that Mr. Rolfe shot, it struck an SUV there in the Wendy's parking lot. Is that correct?
I believe that is what the investigation showed, yes.
And there were civilians in that car. Is that correct?
From what I was told, yes.
Let me show you what's been marked as Exhibit C18. Actually, we'll keep moving. After Mr. Rolfe shot Mr. Brooks, was he permitted to finish out his shift on active duty?
Was he permitted?
Correct.
He was still on the clock, yes. After a shooting, an investigation starts. EAP is called. We want to make sure that officer is okay. So the officer doesn't, as far as finish out his shift, that officer is not going back on the street to patrol, if that's what you're asking. But the officer was still on the clock.
He was being paid that day.
Correct.
You mean? But he didn't have any responsibilities.
After the shooting, no, we don't expect the officer to continue active duty at that point, other than being available for a investigation to make sure that officer is okay.
So he finished out the day, but not on active duty.
Correct.
Correct. And did he ever go back to active duty before he was dismissed?
To my knowledge, no.
Would an officer involved in a shooting typically be taken back to headquarters rather than finishing their shift on active duty?
They'll be taken back to headquarters or back to their place of, back to their unit, whether it's a zone or a specialized. Some of our units are at different buildings, so they'll either come back to their building or they'll be brought back to headquarters, yes.
And they're paid for that time, correct?
Correct.
Now, the other officer involved that evening with Mr. Brooks, Officer Brosnan, he's been suspended without pay since June of 2020, pending the resolution of his criminal charges. Is that correct?
Correct.
And to your knowledge, has Mr. Rolfe also been criminally charged for his conduct involving Mr. Brooks that evening?
Yes, that was the former DA's discretion. That is what happened, yes.
And it's your understanding that as a result of his pending felony charges, Mr. Rolfe cannot have a weapon or talk with anyone at APD. Is that correct?
That was one of the stipulations, yes.
And with these restrictions, would he have been able, it would be possible for him to return to active duty at APD?
No, that would have been a violation of what the court had ordered.
In his criminal case?
Yes.
Thank you. I reserve the right for redirect and also to recall the witness as if recall may be necessary, because we don't know at this point whether Mr. Rolfe will invoke the Fifth Amendment, and we may have some additional evidence that we may need to bring in through Chief Coit if Mr. Rolfe does so.
All right, Mr. LaRusso, cross. Good morning, Assistant Chief Coit. How are you?
Good morning. I'm fine. How are you?
I'd like to thank you for appearing today. Can you tell the board what FURA leave is? FURA leave?
FURA leave.
I'm not testing the acronym. That's okay.
When that happens, we typically take the officer off of the street to make sure that he or she is physically and mentally okay after the officer involved shooting, and it also gives time to start the investigation.
Okay, and it's typically a 3-day force use reassignment. Is that basically what it is?
Yes, that is the Atlanta Police Department's policy, yes.
And based on the timing of what you said, if anybody has told this board that Chief Shields resigned as the chief of police the date before the effective date of the termination of Garrett Rolfe, that would be a lie, wouldn't it?
If they said that, I don't think she resigned the day before that discipline was put out. No, I don't think that is true.
So let me call your attention to the notice of proposed adverse action. And the documents, you said that you signed that document, correct?
Correct.
And you didn't scratch out Erica Shields' name, you just signed next to hers, right?
Correct. I signed my name. I didn't scratch anything out.
So nothing prevented you from doing that, right?
No.
Okay, so if I was a private citizen and I were to do an open records request for that document, unless I knew what your signature looked like and what Erica Shields' signature looked like, I would think Erica Shields terminated Garrett Rolfe, right?
Yes.
Your printed name does not appear anywhere on the notice of proposed adverse action or the notice of final adverse action, correct?
And recalling how it looked, I don't believe my name was printed on the document, no.
So let's pull up the disciplinary process. It's A5, it's been stipulated to, and it's page 26. There is a time between the notice of proposed adverse action and the notice of final adverse action, correct?
Typically, there is a time, yes.
And that time is in order to give the employee an opportunity to review the investigative file and obtain legal or other representation. Do you recognize that from the policy? And I'll pull it up for you. It's 4.8.2, subsection D, page 26.
Yes, I see it.
So the purpose of the employee response session is to give the employee an opportunity to prepare to have a statement and a meeting with the chief so they can respond to the proposed adverse action, correct?
Typically, that is what happens, yes.
Well, it's not just typically, that's the reason for it, is to give the employee an opportunity to prepare, correct?
Yes, unless there is something that is very egregious, then I believe the chief has the right to immediately terminate someone. But typically, that is the process, the procedure that occurs.
You believe the chief has the right to do that, but you can't cite me to a policy or an ordinance that authorizes that, can you?
No, I cannot. No.
So let's go back to the disciplinary policy, same page 26, 4.8.3.2b. The purpose of the employee response session is to afford the employee the opportunity to answer the questions the disciplinary authority might have, correct?
Yes.
Now, you read 4.2.50 and the standard on use of force, and it references Graham versus Connor, does it not?
Yeah, I don't see it right in front of me, but from my recollection, yes.
And part of the tenet of Graham versus Connor, with a 29-year experience, you understand that the court specifically prohibits the use of hindsight in the evaluation of someone's use of force, correct?
No, I won't quote, but yeah, that may be correct.
Okay, let's look at the disciplinary policy again, the process 4.9.2 on page 30, the notice of emergency disciplinary action. So basically, what you're saying is you signed this document. Do you take ownership of any deficiencies in this procedure in the termination of Officer Rolfe?
What do you mean? Do I take any deficiencies?
If there are deficiencies in this process, since you signed the document, is that on you or is that on former Chief Shields?
Former Chief Shields was still the chief when that document was signed.
So former Chief Shields bore the ultimate responsibility to make sure all of the ordinances, policies, procedures, rules, and regulations of the City of Atlanta were complied with prior to the termination of Officer Garrett Rolfe, correct?
Yes, at that point, I was the only person on the police department that can fire or terminate an employee is the chief. I was the assistant chief, so I did not have the authority to terminate any employee.
Okay, let's go to page 30 of 48, 4.9.2, notice of emergency disciplinary action. So you mentioned in extreme circumstances, there is a little bit of a change in the procedure. Would you agree?
Yes.
And 4.9.2. It states the chief of police or their designee will, not may, will ensure that a completed notice of proposed adverse action is issued to the employee in person or by certified mail. Did I read that accurately?
Yes, you did.
So based on your previous testimony, it was Chief Shields' obligation to make sure that Officer Rolfe received a copy of the notice proposed adverse action in person or by certified mail, correct?
Correct, according to the document, correct.
Now then we look at number 2. There should be at least 5 working days between the date of the notice of proposed adverse action was issued and the date scheduled for the employee response session, correct?
Correct, that's what's stated on the document, correct.
Because if we're gonna give an employee, and they have a right under the ordinances to give an employee response session, they have to have an opportunity to appear and they have to have an opportunity to prepare, correct? We've already established that.
Correct.
Well, June 13th, 2020 was a Saturday, right? Right?
I'm not sure what day it was.
Okay, well, you can take my word for it. It was a Saturday. And you said that everybody was in meetings, right?
We were in various meetings that day, in and out of meetings, correct.
A lot going on, right?
Definitely.
So did somebody tell you the chief was too busy to put her signature on a piece of paper and meet with Officer Rolfe?
Did someone tell me that? Chief and I were in the room and I was asked to sign that document.
Garrett Rolfe wasn't in the room though, was he?
No, he was not.
So 5 working days meant you were required to give Rolfe until Friday, June 19th to have his employee response session, right?
Yes.
And 5 days to prepare as opposed to, let's say, an hour with no preparation, correct?
It states 5 days.
And if you don't have an opportunity to respond, then the policy has been breached, correct?
That would be your argument. Yes.
Well, if you were subject to termination and you got a notice of proposed adverse action and you know you could give an employee response, you'd expect to have at least a little bit of time to prepare, wouldn't you?
Yes, I would.
And an opportunity to get there?
Correct.
So minimum of 5 days per the ordinance, and that's ordinance 114.532. Are you familiar with that ordinance by number? And if you're not, I'm not trying to sharpshoot you. I was just wondering if you're familiar with it.
No, I'm not familiar with it by number, no.
Okay, so let's go to Exhibit A2, the notice of proposed adverse action. So was this an emergency action?
Yeah, I believe it was an emergency action, yes.
Do you know who made the determination that this was an emergency action?
Chief Shields did.
So again, Chief Shields is responsible for making sure that we meet all those requirements, correct?
Yes.
Now, in the upper right corner of the notice of proposed adverse action, this has been stipulated to emergency action is checked yes, and emergency action is checked no. Did I read that accurately?
That's what's on the document, correct.
And I'm not trying to sharpshoot you. I pulled that up because you said you basically were trying to recall it. Did you recall that it said it was an emergency action and was not an emergency action at the same time?
No, I don't. I didn't recall both of the boxes being checked. No.
That's not appropriate, is it?
That's not normally how it's done.
Well, it's an either or. Yes or no are usually two mutually exclusive options, right?
That's not normally how it's done.
So if it's not an emergency action, he actually was supposed to get 10 days to respond prior to the notice of final adverse action. Isn't that correct?
Yes.
And that's pursuant to Ordinance 114-530?
Correct.
And 10 days would have been Friday, June 26th, because it's 10 working days, correct?
Yes.
Yet somebody filled in, if we can scroll down, somebody filled in the time for him to respond. Now, this was created on June 13th, 2020, correct?
Yes, it was June 13th.
So somebody filled in the time for his employee response, the deadline, if you will, of June 13th, 2020 at 4:45 p.m.
Yes.
And again, it says Chief Shields, but we would have no way of knowing that was your signature unless somebody told us, right?
Well, I think it's readable, but yes, yeah.
Well, mine's not readable either, so don't feel bad. I can't read it. So then it says employee did not attend, and there's a witness signature there, correct?
Yes.
Now, you weren't there when that was signed, were you?
No, I'm not sure whose signature that is.
Well, whoever it is signed it June 11th, 2020, correct?
That's what's on the document, correct.
Well, it clearly wasn't witnessed June 11th of 2020 because that's the day before all of this occurred, correct?
Yes.
So for all practical purposes, there's no witness signature on that. It's invalid, isn't it?
There is a signature on there, but for whatever reason, they put the wrong date.
Well, it's important that documents are filled out properly in the City of Atlanta Police Department, correct?
Oh, definitely, yes.
Now, you have police recruits and FTOs?
Yes, we have recruits and field training officers. Yes, we do.
And you have a standard for how many typos can be on a report by a recruit before a field training officer makes him rewrite it, right?
Yes.
Was anybody watching over Chief Shields to make sure that all of these typos didn't appear, like wrong dates and emergency action, yes or no? And no?
Was anyone watching over her? I'm not familiar with that anyone was watching over her, no.
Well, she's the chief. I mean, you shouldn't have to, right?
Correct.
So when we go to the body of this document, and if you can scroll up a little bit, Kayla. If this was an emergency action, there's supposed to be documentation of the reason for the emergency action, correct?
Sometimes, yes, there is writing or documentation in that narrative box, yes.
Well, are you familiar with Ordinance 114-532, Section B, that says, shall give the employee against whom the emergency action is taken a notice of emergency action in writing not later than 5 days after the date of the emergency action?
I'm not familiar with that ordinance specifically, no, I am not.
But you would expect Chief Shields to be familiar with it, correct?
Yes.
And Section 98-28 of the ordinances requires the police chief to follow ordinances, policies, procedures, rules, and regulations when taking any employment action, correct?
I can't say correct because I'm not familiar with that ordinance and I don't see it on the screen.
And that ordinance, why don't we pull up 114-532, Section B? It states the notice of emergency action shall, again, not may, shall include a statement of the emergency action that caused the action to be taken, correct? We're going to blow it up there so we can both read it. Second sentence. The notice of emergency action shall include a statement of the emergency situation that caused the action to be taken. Did I read that accurately?
Yes, you did.
To be taken is future tense, correct?
Yes.
So you can't fire somebody and 5 days later send them a notice and say, hey, we fired you under an emergency situation, so here's your notice. That does not contemplate it in the ordinance, is it?
It didn't appear to be.
And in this case, the action was a termination, correct?
This for this, yes, that was a termination.
So while you have Rolfe on FURA leave, he's allowed to be outside the city, correct?
Yes.
And nothing prevented you or the chief from having the notice of proposed adverse action personally delivered to him, did it?
No.
And that's been done before with the city of Atlanta with either sensitive documents or OPS-based stuff. They drive it out to the officer, don't they?
Yes.
You agree that the mayor had no authority to fire Garrett Rolfe, right?
I won't say the mayor did not have authority. Typically, the police chief makes that decision, but I won't say the mayor does not have authority.
We'll have to just defer to the lawyers on that. Fair statement?
Definitely.
Okay. Let's go to the disciplinary process, 5.26, page 46 of 48. It's A5. You're familiar with a priority 1 complaint?
Yes.
And that's an allegation of a major nature within the city of Atlanta, an allegation of misconduct of a major nature. Fair statement?
Yes.
And that's a complaint is of a serious nature, or the complaint alleges the employee's conduct caused or resulted in serious injury. The complaint alleges that unauthorized force was used and there's evidence of serious injury. Did I read that accurately?
I believe you did, but nothing is on the screen.
Okay, well, technology is awesome when it works. Bear with us a second. You're familiar with a priority 1 complaint is required to be investigated by OPS, right?
Yes.
Let's move on to the conducted energy weapon policy stipulated admissibility at A6. And you would agree that the allegations made in this case clearly outline a priority 1 complaint?
Yes.
Are you familiar that the conducted energy weapon policy states OPS shall investigate suspected work rule violations arising out of an employee's use of a CEW?
Yes.
And it actually references the disciplinary policy, does it not?
Yes, it does.
And that's at 3.7, if you can just pull that up, Kayla. Okay, well, I'll just note for the board has that, it's 3.7. Let's go to the use of force policy, which has been stipulated at 3.6. OPS will investigate suspected work rule violations arising out of an employee's use of force in accordance with APD disciplinary process. You're familiar with that, correct?
Yes, I am.
And the work rules policy, which has been stipulated, all violations of work rules shall be investigated fairly, uniformly, and equitably, correct?
Correct.
Okay, let's go down to the use of force policy here to 3.6. And just for the board's benefit, I apologize, we're having a little bit of a lag. So there it is, 3.6. The Office of Professional Standards will investigate suspected employee work violations arising out of an employee's use of force in accordance with the disciplinary policy, correct?
Correct.
Now, OPS never interviewed Officer Rolfe about this case, did they?
I am not familiar with if they did or did not.
Well, you agree, based on what we've gone through, 4 separate policies in the city of Atlanta require OPS to do an investigation of a priority 1 complaint, such as it's outlined in the notice of proposed adverse action, correct?
Yes.
And you never met with Officer Rolfe for his employee session, correct?
No, I did not.
Do you agree with Chief Shields' statement to the AJC on January 7th, 2021, that it's unfair to judge an officer from a snippet of video?
Oh, yes, I agree with that.
And that's why we have OPS do in-depth investigations, including statements from the officers, correct?
Correct.
Now, the notice of final adverse action, which is Exhibit 3, let's pull that up a second. Let's go to the top. That again has emergency action, yes and no, correct?
Yes, that's what's marked. Yes.
Now, you didn't do that, right?
No, I did not.
Okay. And Chief, I'm not trying to beat up on you. I'm just pointing these things out. But clearly somebody else did that, right?
Yes, that was filled out by someone else. Yes.
All right. So let's roll down a bit. And the statement employee did not attend is also handwritten in there. You don't personally know whether he attended or not, correct?
Correct.
And you were not there when a union rep supposedly received documents on behalf of Officer Rolfe, correct?
Correct.
And Chief Shields was not there when a union rep supposedly received documents on behalf of Officer Rolfe, correct?
I'm not aware of that.
Okay, well,
I do not know.
She was in meetings, right?
She was in meeting. We were both in meetings at various times of the day, but I don't know if she was present when a union rep was there. So I cannot answer that with a yes or no.
Let me ask you this. If you were not there when the union rep showed up to reportedly receive documents on behalf of Officer Rolfe, and Chief Shields was not there, then there was no opportunity for Officer Rolfe to provide an employee response session, was there?
No, there would not have been.
Now, the mayor's press conference announcing the termination of Officer Rolfe was on June 13th, 2020, and began at about 1700 hours, right?
I don't know what time it began, but it was that same day, yes.
Shortly after 4:45, when the time had expired for Officer Rolfe to provide an employee response session?
Again, I'm not sure what time it started, but it was on that same day.
Were you there at the press conference?
No, I was not.
Chief, I heard you say a moment ago that the only criticism you had of Officer Rolfe was that the interactions with Mr. Brooks should have taken place closer to a patrol car.
That, to me, that was not a criticism. I was asked what I may have done differently, but that by no means was that a criticism.
And that's the only thing you would have done differently on June 12th?
Yes.
That's all the questions I have.
Any redirect, Ms. Lawrence Hardy?
Yes, brief redirect. Thank you. Chief Coy, to be clear, the chief, former Chief Shields, is the one who exercised her disciplinary authority to terminate Mr. Rolfe. Is that correct?
Correct.
And in an emergency dismissal under Code Section 530A, which here is Exhibit C7, I can show you again if you'd like, the adverse action can be effective immediately after the employee response session. Is that correct?
That is my understanding, yes.
And let's look at Exhibit C7. I want to show you that in 530 C2A, we have the language within 5 working days. And within here means within. Is that correct? Is that your understanding?
Yes,
And that could be 2 hours or 5 hours. Is that right?
that is my understanding, yes.
And would you agree that the city code controls over APD standard operating procedures if there appears to be a conflict, such as between 530C2A here within 5 working days and the language that Mr. LaRusso showed you from 4.9.2 of the SOPs where it says at least 5 working days? The city code is the ultimate decider. Is that your understanding?
That is my understanding. We try to make sure that our operating procedures don't violate city code.
Because city code is the ultimate authority that's granted, correct?
Correct.
And here, even if the dismissal process were slowed down, would you agree that the best case scenario for Mr. Rolfe, who was charged with felonies, is that he would have been suspended without pay since last June, just like Officer Brosnan?
You said the best case scenario?
Correct, if it had gone differently in terms of the dismissal process.
Yes. Typically, if someone is suspended and charged with felony, and they're charged with felonies, they are suspended without pay.
And that's the case with Officer Brosnan, correct?
I believe so, yes.
And he's been suspended without pay since last June.
I believe so, yes.
Thank you. No additional questions. Although, again, we reserve the right to recall Chief Coy if necessary.
Recross?
Yes. We've heard a lot about this 114.526. It states removing an employee under extreme circumstances from the work environment. It's possible to remove an employee from the work environment without terminating them, isn't it?
Yes, it is.
And y'all have done that on numerous occasions with officers when there's death threats for them, when there's issues that may be a fitness for duty, or there may be a FURA, for example. They're removed from the work environment, correct?
Correct.
So the FURA leave is no different than someone just being removed from the work environment for some other reason. It's not a suspension and it's not a relief of duty, is it?
FURA is not a suspension, no, and it's not a relief of duty.
It's a change in assignment, essentially, a temporary change in assignment.
Yes.
And when you have an employee who is facing charges, they can return to the City of Atlanta employment on what's called non-enforcement duty, correct?
Yes, but typically, as I stated, if they are charged with a felony, they aren't allowed back to the work environment.
In 29 years, Assistant Chief Coit, you have seen officers facing felony charges that are returned, listed on non-enforcement duty, and they are not suspended without pay. Is that a fair statement?
I would not say that's a fair statement, no.
Do you know Officers Gardner and Streeter?
Yes.
Do you know their current status?
No, I do not. They were, I believe they are, they just had a hearing, did they not? And initially they were suspended without pay.
I don't have any further questions. Thank you, Chief.
Does the panel have any questions? Hearing nothing. Chief, let me ask you something. What is FURA? What does that stand for? And what, I'm at a loss. How do you spell it? What does it stand for? What's the purpose of it?
FURA, I'm having a brain fart right now. It's FURA, and it's basically, as we stated earlier, when an officer is in an officer-involved shooting, they are relieved for a minimum of 3 days, again, to make sure that that officer is both physically and mentally okay, and it gives the department a chance to start the investigation. We want to make sure that that officer is it's fine, officer, after the officer involved shooting.
Okay, and I think you said, when Mr. LaRusso asked you, you said that when there's an officer involved shooting, EAP is called. That's Employee Assistance Program,
Yes.
right?
I'm sorry, Employee Assistance Program, yes. EAP.
Right, okay. All right, again, panel have anything?
Ms. Eves, if I could, it's Force Usage Review Assignment. FURA, Foxtrot Uniform Romeo Alpha, Force Usage Review Assignment. I apologize
Okay.
for bringing it up before.
Okay, Ms. Lawrence Hardy, anything further, Chief?
No, thank you.
Okay, and Mr. LaRusso, no?
No, Your Honor, thank you.
All right, so, Chief, thank you so much. Please go to wherever you need to go and have a great day, but please do not discuss your testimony with anybody. Hold on just a minute. Ms. Lawrence Hardy is.
I just wanted to remind the chair that we have reserved the right to recall Chief Coit, so I just wanted him not to go too far.
Thank you. So Chief Coit, we're going to put you in the waiting room is what it's called.
Okay.
And you may be recalled later on. Thank you for reminding me, Ms. Lawrence Hardy.
All right, thank you.
Thank you. All right, your next witness, ma'am.
We now call Sergeant William Dean.
And these are estimates about 5 minutes old. The city's used about 33 minutes, the appellant 35. And you'll remember, I don't think I said it at the beginning, but you'll remember this is a 3-hour hearing. There is a second hearing scheduled behind this afternoon. Sergeant Dean. You're on mute.
Okay.
There you go. How are you doing today?
I'm all right. How is everyone?
I think everybody's fine. I'll just speak on behalf of everybody. My name is Sterling Eves, and I'm the chairman of this panel today. With me is Mr. Alameen and Mr. Hawkins. Do you have any objection to taking an oath or an affirmation?
I do not.
Would you please raise your right hand? Do you solemnly swear or affirm that the evidence you will give before this hearing will be the truth and nothing but the truth?
I do.
Thank you, sir. Please tell us 3 things. If you would tell us your name and spell it for the court reporter. Secondly, tell us what your position is with the department. And number 3, how many years you've been there.
Okay. My name is William Dean. It's WILLIAMDEAN. I've been with the Atlanta Police Department since 1995. I'm currently assigned to Internal Affairs, where I'm a sergeant in the Advocacy Unit.
Advocacy Unit. Thank you, sir. Ms. Lawrence Hardy.
Thank you, and good morning, Sergeant Dean.
Good morning.
You've been in OPS since 2006, is that correct?
That's correct.
And have you been the advocacy officer that entire time?
No, I think I took over maybe 2011, 2010.
As advocacy officer.
Yes.
And I know you've testified before this board before, but can you just remind all those who are watching what the role of the advocacy officer is in OPS?
The advocacy unit prepares formal charges for the disciplinary authority, any adverse action, which are suspension days for the whole, police department. And we work with the law department.
And part of your role as advocacy officer is reviewing disciplinary procedures and identifying problems in the process. Is that correct?
That's correct.
And that's something you've been involved with since 2011?
Yes.
I'd like to show you Exhibit C1, which is Mr. Rolfe's NPAA. Did you assist with drafting this document?
Yes, I did assist with drafting it.
And here at the top of the first page, we see both yes and no checked under emergency action. So as you can imagine, that's been a source of a bit of confusion this morning.
Well, I could clear it up. It's a typo. It was a very rushed situation. This was an emergency action. So therefore, there should be no check in the no box.
It should just say yes, correct?
Correct.
And based on your years of experience, APD, and particularly with OPS, can an emergency action include immediate dismissal without the standard 10 days notice of charges to an officer?
Yes, I've seen it before.
I'd like to show you Exhibit C6, which is Atlanta City Code, Section 114-526. Looking at the second sentence, you'll see the following. Quote, when an infraction is such as to impair or destroy the future effective performance of the employee, the employee's presence impairs the effectiveness of others or presents danger to the employee, others, or city property, action shall be taken to immediately remove the employee from the work environment. Did I read that correctly?
Yes.
And the code does have this provision, correct?
That's correct.
I want to now show you Exhibit C22, which is a clip from Mr. Rolfe's body-worn camera following the 3 gunshots Mr. Rolfe fired at Mr. Brooks. I will pause now so that we can see this footage.
Yo, fucking taser. Oh, 63. Put your hands on your back. Put your hands on your back. Stop fighting! Come on, man! They shot the man, Man, that's messed up, man. Watch these fucking kids. Watch these and these fucking assholes shooting in the Wendy's drive-thru for no fucking reason. For no fucking reason. Shot him. Man, we right here. I saw y'all talking to him for 20 minutes, dude. Unarmed, non-violent, nothing wrong with how he conducted himself whatsoever. And you pull a fucking gun, dude? Wow. Wow. I feel like both of your careers are definitely done because you just shot a man for no reason. This pig and these two. Yeah, suspects like your bullet, dude, for no reason. Jumbling with the fucking glove, you fucking clown. Fucking disgusting. Fucking disgusting, dude. We sat there, watched these fucking pigs harass him for 20 fucking minutes for no reason. And then you fucking shoot him? The fuck? Fucking pigs, dude. Every fucking time. Fuck. That's fucking gross, dude. I just watched this shit happen. They harass him for 20 minutes behind his fucking car for no fucking reason. How can they shoot all these people? Bro, they don't give a fuck. They don't give a fuck. Wow, dude. What the fuck? Dang. What the fuck, dude? Dude. How you gonna check them? Bruh. What the fuck? Was anyone recording that shit? Like when fucking... Yeah, like, yo, dude, These fucking cops did that shit unnecessary as fuck. We watched, dude, man. We watched him for 20 Right. He's standing in the street. All right, man. I saw these two cops talking to this gentleman, and they were having polite discourse the whole time. You know what I'm saying? This dude was not being aggressive. He was talking. He was like, yeah, you know, whatever. Getting harassed for no fucking reason. And then I think he realized that they were going to arrest him for no fucking reason. So he, like anyone else that's going to get arrested for no fucking reason, was like, fuck that. And he ran away. His car is here. He's gonna come back. Why the fuck would you shoot him? I mean, his car is here. If you leave your fucking vehicle here, why the fuck do you need to shoot somebody, bro? The fuck?
Listen, right now what we gotta do, we gotta make sure no evidence is disturbed. We gotta make sure whatever the real story will come out. So, if anybody got something to add to it, want to speak to a supervisor or something, you're more than welcome to stay. If not, y'all gonna be stuck there for a while. So we're gonna shut the whole scene down.
Bro, I'm not talking to a white cop that just killed a guy. First of all, and I'm not gonna talk to a supervisor who would ever defend a fucking white cop that just shot a guy for no fucking reason.
I get you. That was messed up.
The fuck, dude? For no reason, bro. All of us saw that shit. He didn't do shit. He didn't do shit. He didn't do a fucking thing, dude. I saw the whole fucking thing.
And Sergeant Dean, I apologize to you and to everyone for both the language and obviously the traumatic nature of the content. We've got to get through the evidence, of course, in the case. Do you recognize the footage we just saw as footage from Mr. Rolfe's body-worn camera as kept in the ordinary and usual course of business by the APD?
I recognize the video, but I don't know if that's Rolfe's or Brosnan's body cam.
Okay, you recognize it's the body cam of an APD officer?
Correct.
Okay, and it would have to be Brosnan or Rolfe, correct?
I'm pretty sure it's one of them, yes.
Okay. I will represent to you that it's Rolfe's, but it's completely fair. I just need you to testify that it's kept in the ordinary and usual course of business by the APD. Is that accurate?
Yes.
I'm going to show you one more video. And again, I want to make sure we apologize for the traumatic nature of the content. This one is marked as Exhibit C31.
Please.
Oh shit.
What?
Damn. Fuck. Oh. I got it. Hey, bro, we got kids. Right.
This was video posted to social media from a civilian cell phone. Do you recognize this video depicting the evening of June 12th, 2020?
I do.
Particularly given some of the bystander commentary that we just heard, do you agree that Mr. Rolfe's conduct affected the way the public viewed the APD?
I mean, in which manner are you referring to?
I'm referring to the extensive language that we heard from the bystanders. Did they have a negative or a positive impression of the APD having witnessed that interaction?
I think it probably would be negative, but I mean, on the tails of George Floyd, I think most civilians had a negative attitude toward law enforcement.
And given that this came just a few weeks after the George Floyd incident, did it sound to you like the bystanders who were in the videos were affected negatively in terms of their perception of the APD by Mr. Rolfe's conduct?
Yeah, it appears that they have a negative perception. Some of the comments seems to be misguided and not accurate, but yeah, they appear to be upset.
And Sergeant Dean, I can play it again. The language was harsh for my ears, and I presume for everyone else's as well. But did you hear the bystander saying this man was shot for no reason?
Yes, I heard that.
Okay. And would you agree that, at least with regard to that bystander, Mr. Rolfe's conduct affected the way he viewed the APD?
You mean that particular citizen?
Correct.
Yes, what he saw probably had a negative impact on how he views us, yes.
Do you agree the conduct that was witnessed that evening that Mr. Rolfe engaged in caused the public to lose trust in the APD?
I mean, once again, if you don't really understand and you have your own opinion and it may be somewhat misguided and closed-minded, then you're going to have your own opinions about APD.
Is that yes?
Yes.
And could Mr. Rolfe's continued presence on the street have impaired the APD's effectiveness in working with the public?
You mean after the incident?
After the incident.
I find it would be highly difficult for him to be able to patrol the streets of Atlanta after this incident, yes.
It would have been dangerous for him to be on duty. Is that correct?
Especially right after this incident, correct.
And certainly disruptive to APD. Is that correct?
Yes, because we would have to protect him. And then we would have to deal with the citizens who were mad that he's out patrolling.
And you're aware that Mr. Rolfe was arrested for and charged with felony crimes for his conduct towards Mr. Brooks, correct?
Correct.
I want to show you Exhibit C4, APD Standard Operating Procedure 20. And I'm going to show you page 43, Rule 5.3. It says the appointing authority is the chief of police, and that the authority of the chief of police includes taking whatever action she deems necessary to protect and preserve order in the Atlanta Police Department. So, taking this APD rule and the code section 526 we just reviewed, do you agree that the chief of police has authority to immediately dismiss an employee?
Objection. It calls for a legal conclusion for the witness, and it's in the province of this board, even so far as going to an ultimate issue.
I can reword. Sergeant Dean, in your experience, is it your understanding that the chief of police has the authority to immediately dismiss an employee?
Yes.
Based on the code, APD Standard Operating Procedures, and your long experience as an advocacy officer with OPS, was Mr. Rolfe's immediate termination procedurally proper?
Procedurally, yes, there were a lot of extenuating circumstances. I mean, we were asking Mr. Rolfe to come to a hearing in the city of Atlanta, which to me would have been completely unsafe and unreasonable for him. I mean, he would have to drive through the city of Atlanta, stop at stop signs, stop at red lights, and be recognized by angry individuals. So I based on what went down in the circumstances, yes, I think it was reasonable.
And based on the circumstances, was Mr. Rolfe's immediate termination procedurally proper?
Yes.
And I'd like to break down the procedure a bit further. Going back to Exhibit C1, the NPAA, here on page 1, there is a response date and time, and then by the employee signature line, I see written, employee did not attend. Did someone else attend on behalf of Mr. Rolfe?
Yes, his IBPO representative, Ken Allen.
And was Ken Allen someone who was familiar to you?
Yes.
He's represented other officers, correct?
Correct.
And an employee is not required to attend this session, is that correct?
He's not required to, no.
And he can send a union rep if you'd like.
Yes. He can respond in writing. He can send a union rep. He can send an attorney. Yes.
All his choice, right?
His choice.
Going back to Exhibit C4, I'd like to look at page 27, Rule 4.8.3, in the second sentence of subsection 4. Here it says that an employee who is unable to attend the session may allow his or her representative to attend the session in their place. Correct?
Correct.
Did someone tell you that Mr. Rolfe would not be attending his response session?
I had conversation with the IBPO and the union, and for safety concerns, number one, they thought that was a good idea for them to sign for him.
And do you remember who with IBPO and the union told you that?
If I'm not mistaken, I know it was Ken Allen and maybe attorney Ramona Jones.
And that's Ramona Bird Jones with the IBPO?
Yes.
And just for the record, what does IBPO stand for?
I would assume Internal Brotherhood of Police.
I think it's international. Is that?
Hey, sounds good to me.
Can an employee also give his or her union, let me just be clear, that's the union, correct?
Yes.
And can an employee also give his or her union representative authority to sign and receive the employee's NPAA?
Yes.
Is that what happened here with Mr. Rolfe, that he gave his union representative, Ken Allen, authority to sign and receive Mr. Rolfe's NPAA?
That's what was relayed to me by the union, yes.
And who was that? Ken Allen and Ramona Bird Jones who told you that?
Yes.
Was Ramona Bird Jones present on site, or did she tell you this in a phone call?
A phone call. Only Ken Allen responded to headquarters.
On site, he was there.
Yes.
And presented himself in person at the time.
Yes.
And going back to Exhibit C1, looking at Ken Allen's signature, we see this date is June 11th. But we can all agree that the incident with Mr. Brooks had not happened on June 11th, correct?
Correct.
So that's just human error?
That's what it appears to be.
On what date would Ken Allen actually have signed this document?
On the 13th.
Okay, and did you see him sign it?
Yes.
Okay, you know that to be a signature because you watched him sign it on the 13th.
Right, and I know his signature.
Because you've seen it on other cases?
Yes.
And here, not only did you recognize the signature, but you actually watched him sign it on June 13th, correct?
Correct, and I gave him copies for the union and also another copy for Officer Rolfe.
I'd like to show you Exhibit C2, Mr. Rolfe's NFAA. Same questions for this document. Did you assist in drafting the document?
Yes.
And up here at the top of the page, we again have some confusion to clear up. I see both yes and no checked under emergency action. Was that again just a typographical error?
Yes. Like I said, this was very rushed. Time was of the essence. So sometimes mistakes happen when you rush.
But this was in fact an emergency action. Is that correct?
Yes.
And again, was it your understanding that Mr. Rolfe's union representative, Ken Allen, would be signing and receiving the NFAA on behalf of Mr. Rolfe?
Yes.
And same thing for C2. We see the date of Ken Allen's signature is June 11, 2020. But again, you saw Ken Allen sign this NFAA on June 13, 2020, correct?
Correct.
And that's his signature on the document.
Yes.
And given the response session scheduled for 4:45 p.m. that day, do you agree that Mr. Allen signed this document? Signed the NPAA and the NFAA sometime between 4 and 5 p.m. on June 13th?
Yes.
Are you able to narrow it down any more than that?
No, I can't narrow it down. Like I said, it was a time limit. It had to be signed at a certain time. So I'm pretty sure it was between that time.
Between 4 and 5.
Yes.
And once Ken Allen signed Mr. Rolfe's NPAA and NFAA, did you make copies and hand those copies to Ken Allen?
Yes.
And then whose responsibility was it to get the papers to Mr. Rolfe?
At that point, if he's representing Mr. Rolfe from the union, I was told he was going to deliver them to him.
Did Mr. Allen tell you that?
Yes.
And you also sent Mr. Rolfe's completed MPAA and NFAA to Human Resources, as you typically do, correct?
Correct.
Putting aside for a moment how Mr. Rolfe handled Mr. Brooks, can you tell me, in your experience as an officer, how you would have handled Mr. Brooks differently had you been the responding officer that evening?
In regards to Mr. Brooks, well, you got to understand I patrolled a while back. And due to the situation with the college students, in my opinion, a lot of officers were somewhat apprehensive and feel like they may have been too aggressive. But I think on the onset, they were very courteous and professional. They explained themselves. Things went far left when they tried to handcuff him. Prior to the attempt to handcuff him, everything was perfect. It was peaceful, it was cordial, it was professional. I don't want to really armchair quarterback people in regards to, their fighting skills, it was definitely a physical assault on the officers, and they attempted to use the taser, which is less lethal. I don't know what else I would have done.
I'm going to show you what's been marked as Exhibit C19. Is this Officer Devin Bronson's NPAA and NFAA?
Yes.
In the narrative part, it says that Officer Bronson was charged with aggravated assault, correct?
That's correct.
And that he was suspended without pay effective June 20th, 2020, correct?
Correct.
And Mr. Rolfe currently has criminal charges pending against him too, correct?
Correct.
Including felony murder and aggravated assault with a deadly weapon? Is that correct?
I think those are the charges. I can't be 100% sure.
Okay. Is it safe to say that had he not been terminated, you would have expected Officer Rolfe to also have been suspended without pay, given the serious felony charges pending against him?
Objection, speculation. It's not his decision either.
Given your experience, what would you expect?
If we were to
speculation.
Miss Lawrence Hardy, can you move along?
Certainly. Sergeant Dean, in your experience as an advocacy officer, do officers with felony charges generally become suspended without pay?
Yes.
Are you aware of any exceptions to that rule?
Yes.
How many?
It's more recent. I would think maybe 2 or 3.
In the last 12 years as you've been in OPS as an advocacy officer?
Like I said, more recently, it has occurred. Usually in the past, it did not. Most of the chiefs stay very consistent. But recently, I do know of officers with felonies that are getting paid.
And what was Chief Shields' practice?
Typically, if they were charged with a felony, it would be suspension without pay, pending the disposition of the court case.
I'm going to show you what's been marked as Exhibit C20. This order's dated August 12, and it modifies the bond in Mr. Rolfe's case. And I'd like you to take a look at paragraph 8 on the second page, where it says that defendant Garrett Rolfe must have no firearms and no contact with any City of Atlanta police officers except emergencies. Are you aware of those bond conditions?
Yes.
And given those conditions of his bond, if Mr. Rolfe were reinstated, could he be an effective APD officer?
If he was reinstated, he would be at home, suspended at home.
Without pay?
It's hard to say. Like I said, recently we have people with felonies getting paid, so I don't know what they would do with Officer Rolfe.
And I'm sorry, let me just be clear. The decision maker here, however, was Chief Shields, correct?
Yes.
And are you aware of Chief Shields ever suspending anyone with pay pending felony charges?
Objection. This calls for a speculation. Obviously, as we've heard, Chief Shields is no longer the chief. So if he's put back to work, this is complete speculation as to what would happen.
Certainly. We are engaged in factual inquiry here. And I'm just asking Sergeant Dean, in his experience working with Chief Shields, whether she ever reinstated anyone, whether she ever suspended anyone with pay who's facing felony charges.
I believe he already answered that and said yes, but you can ask him that again. Sergeant?
Yeah, I thought he said no, so I definitely want to ask to clarify the record. Sergeant Dean?
Yes.
Were you aware of Chief Shields ever suspending anyone facing felony charges with pay?
No. I'm not aware of any instance, no.
Okay. So, Madam Chair, I hope I clarified that.
Got it.
And with that, we will tender the witness. Thank you.
Mr. LaRusso?
Good afternoon, Sergeant Dean. We're about 5 after 12, so I want to make sure I was right. We're going to put up a document, and it's a compilation of some policies to try to save some time. It's A21 in your packet, panel. You have been in OPS since 2006, is that correct?
That's correct.
So you're certainly familiar with the obligations of the Officer Professional Standards to investigate allegations of misconduct?
Yes.
And you agree that under number 1, when there's a use of a conducted energy weapon, hang on a second, we're having some issues. If a conducted energy weapon is used and there's an allegation of misuse or misconduct, that shall be investigated by OPS, correct?
That's correct.
And looking at the second one, if there's a use of force policy, through the use of force policy, OPS will investigate suspected employee work rule violations arising out of an employee's use of force, correct?
Correct.
And if we look at the next one, the disciplinary process policy, allegations of serious misconduct are classified as priority 1 complaints, and a priority 1 complaint involves an injury to a person or a death, correct?
That's correct.
And in a priority 1 complaint, OPS must investigate, correct?
Correct.
Let's go down to the last one. On the work rules policy, it states, it's highlighted there in bold, the Atlanta Police Department shall develop a set of work rules that reflect the highest standards. All employees shall comply. And then the last sentence reads, all violations of established work rules shall be investigated fairly, uniformly, and equitably. Did I read that accurately?
Yes, you did.
Is looking at somebody's body camera for a couple of minutes of testimony or listening to bystanders screaming and hollering with inaccurate statements saying somebody did nothing wrong when according to you they attacked an officer the same as doing an OPS investigation and interviewing witnesses?
Are you asking me just by watching the body cam, is that a thorough and complete investigation?
Right. Is that an investigation that complies with Atlanta policy?
No, I don't think so.
And part of that OPS policy is to actually interview the officers who used force, correct?
That's correct.
And OPS is contacted even if the use of force occurs after hours.
That's correct.
Now, this conversation that you said you had with Ken Allen, we try not to talk about another witness's testimony. Excuse me a second. So when you met with Ken Allen, Chief Shields and Chief Coit were not sitting next to you, were they?
No, I never saw Chief Shields at all.
What about Chief Coit? He wasn't sitting next to you either, was he?
No.
So if, presuming and not admitted, but if Ken Allen was sent by Garrett Rolfe to give an employee response, the chief and the assistant chief were not there to receive it, were they?
No.
Now, you mentioned the safety of Officer Rolfe at the time on June 13th, 2020, at the 4:45 deadline. The videos had been released to the media, correct?
To my knowledge, yes.
Now, it's your opinion. I just want to clarify what you said. After some 26 years with the city of Atlanta, it would not have been safe for Officer Rolfe to drive to that employee response session if it was going to take place at headquarters. Do you agree?
I don't think it would have been safe.
Now, nothing prevented you or the chief or the assistant chief from driving to wherever Officer Rolfe was to present him those documents, correct?
That's correct.
And OPS has driven documents to officers in the past, correct?
Yes.
And when an officer is on FURA leave, they're allowed to be outside the city limits, correct?
That's correct.
It sounded like you said Ken Allen received the notice of proposed adverse action and the notice of final adverse action at the same time. Is that correct?
Yes.
Were they prepared at the same time?
I think so, yes.
But there's supposed to be a time gap between the notice of proposed adverse action and the notice of final adverse action, isn't there?
I think it should be, yes.
Because obviously if the employee is going to give a response, that could change the disciplinary authority's mind, right?
Correct.
And the disciplinary authority listed here was Erica Shields, right?
Yes.
But she wasn't there to receive either in person or through Ken Allen any statement by Officer Rolfe at all.
That's correct.
And you don't have any personal knowledge as to whether or not Officer Rolfe wanted to provide a statement in the employee response session, do you?
No, I didn't. I never spoke to him personally over the phone. It was just a union.
Now, if the response session was going to take place at headquarters and Officer Rolfe had to get to headquarters and it was not safe for him to get to headquarters, then he didn't sound like he had much of an opportunity to respond through the employee response session, did he?
No, I think maybe some different arrangements should have been made for him, but I think it was time restraints involved as well.
And those time restraints had to do with the mayor's press conference at 5 o'clock, didn't they?
I believe so.
So that's why the 4:45 at June 13th appears on the notice of proposed adverse action as the deadline for him to respond. Is that a fair statement?
Sounds fair to me.
Now, are you aware at some point that the video was provided to members of OPS and members of the command staff, the Wendy's video, to determine what happened on the scene at the Wendy's involving Rayshard Brooks?
Yes, I think one of my coworkers probably got it first from homicide. Emailed it to me and I provided it to the chief and the law department.
And obviously we can't tell much from that body camera, whoever's body camera it was, because it's pointing straight up in the air, right?
Right.
And that's not how body cameras are worn, right? Something had to put it on the ground so it could point straight up in the air.
Yeah, in those cases, it's usually knocked off or pulled off.
Did you become aware of Chief Shields' understanding or stated belief as to whether or not Garrett Rolfe's use of force on June 12, 2020 was appropriate under policy and the law?
I never got a chance to speak to the chief, so I don't know.
When you watched the video as a member of the Internal Affairs Unit, you stated that you did not see anything that could have been done differently, correct?
Correct.
I want to show you what's been marked exhibits A18 and A19. Let's try 18 first. You testified about 60 days ago in the Civil Service Board hearings regarding investigators Gardner and Streeter, correct?
Correct.
And I will submit to the board that this is a record from the board. I don't know what else would be necessary to admit this, but let me just see if this witness, have you read this, Sergeant Dean?
No, not in great detail.
Okay. I will move to admit this as a record kept in the normal course of business of the Civil Service Board. In fact, I believe at least one panel member, two panel members on this board were here, and I believe they can speak to with authenticity.
I don't have any.
Ms. Lawrence Hardy.
No objection.
Can you show exhibit A19?
So A18 and A19 are in, or just 18?
I think it's the same foundation for 19. If there's no objection, I'll save the board's time. It's the,
okay.
I will represent 18 is the Civil Service Board order reference appellant Mark Gardner, and 19 is the board's order reference appellant Ivory Streeter.
Any objection?
No objection.
All right, both of those are in. Mr. LaRusso, I hate to interrupt you, but there is a need for a very short break. Are you going to be long with Sergeant Dean, please?
Your Honor, I believe I have two questions, and then I don't think anybody would argue about the break.
Real good. Go ahead.
The terminations of investigators Gardner and Streeter happened approximately 14 days prior to the termination of Officer Rolfe, did they not?
Yeah, roughly 2 weeks.
And in the terminations of officers Gardner and Streeter, or investigators Gardner and Streeter, the city failed to provide them with an opportunity to give an employee response session. Isn't that correct?
That's correct.
And the city failed to put them on leave properly and instead terminated them, correct?
Yes, they were terminated, yes.
And you don't have to terminate someone to remove them from the work environment, do you?
No.
And the city in investigator Gardner, investigator Streeter's case, the Civil Service Board found that the city failed to provide 10 working days prior to the effective date of the termination that was set out on the notice of proposed adverse action, correct?
Like I said, I haven't read it
Okay.
in great detail, but I don't think you would just lie to me.
I wouldn't, sir. I can assure you that.
The order speaks for itself. I don't think it's, I would object to Sergeant Dean having to testify to the contents of a document he has not reviewed carefully.
Mr. LaRusso?
I'll withdraw the question. I will tell you I am done with this witness. I appreciate his attention. I don't believe, now I know he's called as our witness in addition. I do not believe I will need to recall him. I don't want to speak for the city, but just letting you know, I think we're kind of shortening some of our time.
All right. What at this point I'm going to do, we're going to take a 5-minute break. Sergeant Dean, don't go anywhere.
Okay.
We're going to put you in the witness room, and once they're sure, both sides are sure that they are through talking to you, then I'll let you know that you're good to go.
All right.
Madam Chair, I should say I do have a brief redirect for Sergeant Dean, just to.
Okay, so when we come back from break at 12:24, it is now 12:19, then Ms. Lawrence Hardy will have a question or two for you.
All right.
So we don't put you in the witness room. You will remain for just a little bit.
Okay.
Thank you. Oh, good. So we're all back. Ms. Lawrence Hardy, you had redirect questions for Sergeant Dean.
Just a few. Thank you very much. Sergeant Dean, my first question is regarding the investigation. There was, in fact, an OPS investigation and a GBI investigation into the incidents of this evening we're here to discuss today, correct?
You're on mute, Sergeant. You're on mute.
Sergeant Dean, I'll restate it just so the record is clear.
It looked like he almost froze for a second, so he may have had to log back in.
Yep. And I would just ask the board's indulgence, because I know we're watching every minute as we bring him back.
So I will ask Mr. Elamine to give me a latest count, but just generally, so you know, 1 o'clock, as y'all very well know, is the cutoff for the hearing. And boy, I hope Sergeant shows up soon.
Yeah. Yes, the city is at 1 hour and 5 minutes, and the appellant is at 46 minutes. And in general, we count 20 minutes of that 3 hours for us to introduce things and our questions. So each side, we're looking at each side having an hour and 20 minutes, which means the city has 15 minutes left. And the appellant has 34 minutes. Is that right? Yeah, 34 minutes left.
Which means that'll put us way over 1 o'clock, but I know y'all can marshal your resources accordingly. Sergeant Dean, welcome back. Ms. Lawrence Hardy, you have a question you were in the midst of.
Sergeant Dean, there was in fact an OPS and GBI investigation regarding the incident of June the 12th, 2020, correct?
Yes, but I think it was most of the information was after he was dismissed.
But both of those occurred, correct?
Yes.
And Rolfe was given an opportunity to provide a statement then, is that correct?
Yes.
And if you knew an officer was not going to appear to a response session because the union rep told you so, then does it work to do the NPAA and the NFAA at the same time?
If I knew he was not going to attend?
Correct.
I don't see a problem in that.
No further questions. Thank you.
Mr. LaRusso, anything?
Two things. First, you mentioned that I asked you if you ever heard anything about Chief Shields' opinion about the use of force, and you said you didn't speak to her. Did you hear from any source whatsoever whether or not what the chief's opinion was of the use of force?
I don't know. It was very awkward and odd. I show up for the NFAA, and when I get there, they tell me she's not going to be the chief after 5 o'clock. So I don't know.
But it was after 5 o'clock, right? She was still the chief at 4:45?
I assume she was.
You ever see an officer fired from the city of Atlanta police without an investigation?
I've never seen an officer dismissed for firearm usage without an investigation.
That's all I have. Thank you.
Okay, so panel, do you have any questions of Sergeant Dean? No. Does anybody want to hold on to him for any reason? Ms. Lawrence Hardy, Mr. LaRusso?
Not from appellant.
I'm sorry?
The city,
okay.
with him being released.
Thank you. Sergeant Dean, thank you so much. You are good to go wherever you need to go. Please do not discuss your testimony, and thank you for your time today.
All right, you guys have a good day.
You too.
Thank you, sir.
Ms. Lawrence Hardy, last or next witness. I think it's your last. I'm not sure.
My second to last, Officer Devin Bronson, please. The city would like to call.
Brosnan?
Brosnan.
Okay.
Brosnan.
All right. And so in the witness room should be his attorney?
Correct. Don Samuel. Yes.
There he is. Okay. All right. Mr. Samuel, if you'll take yourself off of mute, I hope you don't disconnect yourself. Should be down in the, I think it's in the bottom left. So Mr. Samuel, you're looking for the place to unmute through Zoom, correct?
My second to last, Officer
There we
Devin
go.
Johnson, please.
Here we go. Okay, so Mr. Samuel, your client has been called by Ms. Lawrence Hardy.
Brosnan.
Okay.
Brosnan.
All right, and so in the Mr. Samuel, do you have YouTube running? Attorney?
I do have
Don
YouTube
Samuel.
running.
Can you disconnect from
There we go.
YouTube because it's going to be impossible for all of us to stay focused?
I'm off mute, I believe.
Okay, are you still on YouTube?
I just
No.
disconnected YouTube.
Good.
I'm managing to
Good.
do all these things. It's rather remarkable this is getting accomplished. Can I make a quick
a
statement?
miracle of miracles.
It is a miracle.
So, Ms. Lawrence Hardy has called your client to testify.
Yes, and I have explained to her and to Mr. LaRusso that he is currently facing criminal charges and is not going to answer any questions based on my advice, based on the Fifth Amendment right to not incriminate himself in any way, shape, or form. He's more than willing to answer his name, and I've instructed him on my advice not to answer any other questions about the events that night.
Ms. Lawrence Hardy, do you want to respond to that? I mean, is there anything else you're going to be asking him?
So every question we have today is regarding June 12th, and the incidents of that evening. And I apologize for the inconvenience, but let Mr. Samuel know that I did need Mr. Brosnan to come state that on the record. And so I would have just one question for Mr. Brosnan.
All right. Hang on just a minute. Mr. Brosnan, I need to swear you in. By the way, I'm Sterling Eves. I'm the panel chair today. And with me is Mr. Hawkins and Mr. Elamine. Those are the other people you see on the screen.
It's a pleasure to make your acquaintances.
Yours as well. Would you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm that the evidence that you'll give before this hearing will be the truth and nothing but the truth?
I do.
You can put your hand down. Sir, would you please tell us what your name is and spell it for the record? And Mr. Samuel, by the way, if I say anything to run astray of your admonition of your client due to the Fifth Amendment, please holler out.
You can count on it.
Okay. So, Mr. Brosnan, spell your name for the record, please, sir.
Yes, ma'am. Devin, D-E-V-I-N. My last name is Brosnan, B-R-O-S-N-A-N.
All right. So, Ms. Lawrence Hardy, you had one question.
Mr. Brosnan, based on the advice from your counsel, you intend to invoke the Fifth Amendment as a response to any question I ask about the events of June 12, 2020, and the shooting of Mr. Rayshard Brooks. Is that correct?
That is correct, ma'am.
Then I will not have any further questions because to ask them would gain only the same answer. So I thank you.
Mr. LaRusso, just in fairness, do you have any questions of?
Absolutely not, for the same exact reason, Your Honor. I have no desire to even get close to the line of the Fifth Amendment.
All right. So, Mr. Brosnan, thank you for appearing today. Mr. Samuel, good to see you.
Good to see you too.
Y'all are both good to leave Zoom at this point.
Thank you.
Thank you.
Thank you for your time.
Thank you.
Your next witness, Ms. Lawrence Hardy.
The city calls Garrett Rolfe.
So, Mr. LaRusso, if you'll Yeah, thank you. We had discussed before, just to remind you and everyone, that there is, as I understand it from you, a pending criminal case still in the county of Fulton regarding this incident, that your client was charged with felonies. And that part of the bond condition is that he have no contact with Atlanta police. And for that reason, he is not appearing physically. We're not seeing his face on record here today. And so at this point, please address these issues, that issue, and then whatever other issue you want to about Ms. Lawrence Hardy calling your client to testify.
And I appreciate that. So very similar to what we heard from Mr. Samuel, let me state there are some questions about background, about when he started with the police department, where he worked, his time in the police academy, the fact that he worked in the went to DRE school. The bottom line, he has absolutely no intention, and I have instructed him, and he has asked me, and that has been my advice. He cannot be called to answer any questions concerning the events that occurred on June 12th, 2020, under the federal Constitution, under the Fifth Amendment, also under the Georgia Constitution, Article 1, Section 1, Paragraph 16, and also under OCGA 24505. Now, I would also respectfully point out in Hoffman versus U.S., the court has very clearly stated guidance for bodies such as this, that even asking why he is pleading the fifth or asking why he believes a question would be incriminating is a violation of the Fifth Amendment. So I just want the board to understand, if he is sworn and starts answering questions past his name, past some background questions of where he worked with the police department, when he started, anything that has anything whatsoever to do with the events of June 12, he is going to plead the fifth, and that is his constitutional right to do. And as we said at the outset, he is challenging the due process. He is challenging the procedures for this adverse action. I said that in the outset, and that is all we have done during this hearing.
Thank you. Ms. Lawrence Hardy, do you want to respond to that?
Madam Chair and members of the board, we certainly respect Mr. Roth's Fifth Amendment rights. We are not here to try to infringe upon them. I certainly, as with Mr. Brosnan, have to get a statement on the record for him to have some understanding of what he will not testify to until the record is clear.
All right, thank you. Mr. Rolfe? I'm sorry, go ahead. Mr. Rolfe, if you'll take yourself off of mute. If somebody's volume is up very high, if it has their microphone on, there we go. Mr. Rolfe, is your volume up real high?
1 second. Is that better, Your Honor?
Much better, thank you. So, Mr. Rolfe, I'm Sterling Eves. I'm the chair of this panel today.
Hang on, he can't hear, Your Honor. Hang on.
I think that was what we were getting. Reverberation.
There's the volume button on this. See if that works. Can we try it? Can we try again?
We're back to echoing.
It sounds like you can't do it with two apparatuses in the same room. You have to, if you're all in the same room, the two are going to feed off each other.
All right.
I think we're okay now if you want to test.
All right.
Okay.
So, Mr. Rolfe, do you have any objection to taking an oath or an affirmation?
No, ma'am, I do not.
Would you raise your right hand? Do you solemnly swear or affirm that the evidence you will give before this hearing will be the truth and nothing but the truth?
I swear.
Thank you, sir. You put your hand down. If you would, please, for the record, tell us your name and spell it.
Garrett Rolfe, GarrettRolfe.
All right. And Mr. LaRusso, you are there with him, and Ms. Lawrence Hardy is going to ask him some questions. And so you're there to help your client through this, correct?
That is correct.
All right. Ms. Lawrence Hardy, your witness.
Mr. Rolfe, you intend to invoke the Fifth Amendment as a response to any question I ask about the events of June 12, 2020, and the shooting of Rayshard Brooks, and about the process which led to your dismissal from the Atlanta Police Department effective June 14, 2020. Is that correct?
Yes, ma'am, that's correct.
I don't believe that's what I set out. And I believe there are questions pertaining to the notice of proposed adverse action, the opportunity to appear, that probably would be answered.
Okay, I'll just go through my outline then. You can invoke the Fifth where you like or not. Mr. Rolfe, you shot 3 bullets at Rayshard Brooks while he was running away from you and struck him twice, killing him. Is that correct?
I wish to assert my rights under the Fifth Amendment of the United States Constitution, the Georgia Constitution, and state law, and I will not answer that question.
And at the time you shot Rayshard Brooks, the Taser 7 he was holding had already been deployed twice and had no more cartridges that could have caused harm. Is that correct?
I wish to assert my rights under the Fifth Amendment of the United States Constitution, the Georgia Constitution, and state law, and I will not answer that question.
You authorized the You authorized the IVPO, Lieutenant Allen, to accept and sign your NPAA and NFAA on your behalf, and to appear at your employee response session regarding your termination, correct?
I do not recall giving anyone authorization to appear for me or give any response on my behalf.
Did you have any conversations with Ken Allen regarding the incidents of June 12th, 2020?
Regarding the incident itself or regarding the hearing?
Regarding any of it?
Yes, I did.
Okay, please tell me what occurred in those conversations.
I wish to assert my rights under the Fifth Amendment of the United States Constitution, the Georgia Constitution, and state law, and I won't answer that question.
Okay, Mr. LaRusso, I'm confused. So I tried to listen very carefully when you outlined what he would and wouldn't testify to. I was actually quite surprised when he did testify, gave a substantive answer about the paperwork. Sounds like there's parts of that he will testify to and not. I just want to be mindful of the board's time. Can you specify what the contours are?
Well,
what the testimony will be so that we can just streamline it? I mean, I've got.
Well, let me get in here. Ms. Lawrence Hardy, I understood what the parameters are. At this point, my understanding, and correct me if I'm wrong, Attorney LaRusso, if it's about his background or his experience, that's fine to ask, he will answer. If it's about anything else, he's been given the advice to assert his Fifth Amendment rights. So
only
background, y'all, if everyone will be, hold on just a moment. So, you know, you are running out of time, Ms. Lawrence Hardy, as you know. Ms. LaRusso has some left. He could call his client on direct if he wanted to and get the background information. So that's what I want to say. Mr. LaRusso, do you want to respond to Ms. Lawrence Hardy on her confusion about your client testifying?
It's a difficult thing to respond to. I think her questions are overly broad and conflating two different issues, and I think that's the concern. But I do intend to put some information on direct, and if I could suggest that, maybe if I do that, there will be the information will come out that's necessary without trampling on the areas that we've said are off limits.
And of course, Ms. Lawrence Hardy, you'd have an opportunity to cross-examine him at that point.
Well, and Madam Chair, I certainly can rely on your description of he will only testify as to background and experience. I don't have any questions about his background and experience.
Okay, so then you are through with this witness?
If that's all he's going to testify to, but just a moment ago, he testified to something he discussed with Ken Allen or did not discuss. So I just want to make sure that I'm agreeing to the contours of, I have no questions on background and experience. That I agree with.
Last word, Mr. LaRusso. On this point.
I have nothing else to add to that. I think that there's a way for us to move forward without running afoul of this issue.
All right. So at this point, Ms. Lawrence Hardy, you said you have no further questions. Does the city rest, or do you have another witness?
The city rests.
Now, hang on to that thought just a minute before you put a period on it. Are there any of the exhibits that you've mentioned and talked about and had witnesses testify to that need to be entered into the record that were not stipulated?
If so,
now I need for y'all to go back and look.
I would move to enter any exhibits that we have shown that are not currently in the record.
Did we put up anything that wasn't stipulated?
Our people are both checking.
I have just, for conversation, C1, C2. There are some procedures, of course, in here that you had. C31, C4, C19 and 20 were already were agreed to, and then that was it. That's all I had. So, Mr. LaRusso, question to you. Is there anything that you're aware of that you would object to that the city discussed with its witnesses?
No, Your Honor, just very briefly, I think everything that we've talked about except for 18 and 19, which are board documents, and Allegra, I'm trying to shorten this too for both of us, and I believe Exhibit 21, which is our demonstrative, I think other than that, everything's been stipulated to. I think we worked hard to try to get those stipulations to save time.
Okay.
Are there any ordinances that we've mentioned, Your Honor, that you believe were not into evidence? That's I believe they all were.
I believe they were too. Ms. Lawrence Hardy?
We just want to make sure that C21 and C31 are both in evidence. We have them up with Sergeant Dean.
Okay. C21 and 31, Mr. LaRusso, did you have any objection to those?
Let me figure out which ones they are, please. C21, are you talking about the videos? Are those the videos, Allegra?
Yes.
No, I mean, I don't think I don't think they really had any relevance to whether or not he was terminated properly, but I mean, they've been played before the board, so objecting at this point is a little late.
All right, so they'll be in for the record. So at this point then, city rests, Mr. LaRusso, it's your case. Mr. Elamine, he has, by my math, 10 minutes in round numbers.
Well, to sort of the dilemma, Judge, that we're going to go over for Mr. LaRusso to have the same time that Ms. Lawrence Hardy had. He actually has 26 minutes.
Okay, but he's going to be mindful to shorten it up. I know he will.
Right, and then they both have closings.
Right. Thank you, sir.
And Your Honor, can I inquire, can you tell me again, and I understand it's not a hard stop and y'all have been very pleasant about this, but what is your general hard stop for the board so they can have a break before the next hearing?
People have to be able to eat between hearings. So I would tell you that the hard stop is about 1:15, at the very latest about 1:25, and that's for everything both of y'all are going to say. Can you live with that?
We have been
and I guess even if you can't, that's it.
We have been so admonished.
All right. So, Ms. LaRusso, proceed.
Are y'all able to hear us?
Yes. Yes.
Are you able to hear us? Okay, can we get a sound test so we can make sure we can hear you?
And we can hear you very well. Can you hear us? Can you hear me?
I can hear you just fine.
I think the appellant is having trouble hearing us. Mr. LaRusso, can you hear me?
I can hear you. Okay. How's that? Okay. Officer Rolfe.
Mr. Hawkins, you're all right?
I'm good.
Okay. Go ahead, Mr. LaRusso.
Thank you. Officer Rolfe, can you tell us at what age you entered the Atlanta Police Academy?
I was 20 years old.
And why didn't you go to college? Why did you go to the police academy instead?
I was actually in college when I got hired by the Atlanta Police Department, but I knew from a very young age that being a police officer is what I wanted to do.
And how did you succeed in the police academy?
I graduated top of my class as valedictorian.
And how many people were in your class?
I believe we started with 53.
And how many finished?
26.
Now, when you graduated as valedictorian in the traditions of the City of Atlanta Police Department, does that give you a right to choose your zone?
It does.
And you chose Zone 3?
Yes, I did.
And can you tell us the general boundaries of Zone 3 for the purposes of the board?
Southeast Atlanta, south of I-20, encompassing neighborhoods such as Lakewood Heights, Mechanicsville, Pittsburgh, down to Cleveland Avenue, and to the termination point of the southeast ends of the city.
At some point, were you selected for drug recognition expert school?
I was.
And can you tell the board how long that school is?
It's 160 hours. It takes approximately 1 month.
And is it recognized as a very strenuous academic course?
It is.
One of the most strenuous in law enforcement, would you agree?
That's what they say.
And how did you do?
I was the class valedictorian.
Why did you want to focus your work with the police department on DUI detection?
I saw that there was a great need for it. Many officers weren't familiar with the proper way to conduct DUI investigations. And in my time in Zone 3, I saw the damage and carnage that DUI drivers could cause.
Did you receive an award from the Mothers Against Drunk Driving in 2019?
I did.
And what award was that?
It was the Silver Pin for making more than 50 arrests.
At the time of June 12th, 2020, were you working through the Atlanta Police Foundation to try to buy a house in Zone 3?
Yes, I was.
And can you tell us why you chose Zone 3 as a place that you'd want to live?
I believe that it's important for officers to be members of the community that they're policing. I worked in that area for many years. I had grown to know members of the community and the officers that worked it.
Now, it's been stipulated that you were familiar with Work Rule 4.2.50 prior to June 12th, 2020. Did you violate Work Rule 4.2.50 on June 12th, 2020?
No, I did not.
Tell the board how you first found out that the notice of proposed adverse action had been prepared and that your termination was contemplated.
I received a phone call.
And what time did you receive that phone call?
Approximately 3:45 p.m.
On the 13th of June?
Yes.
And I'm going to try to save time not putting it up for the board, but the NPAA lists a response deadline of 4:45 p.m., does it not?
I had never seen it prior to this point, but yes.
But you've heard that testimony that basically at 4:45 p.m. was the deadline on June 13th for you to respond?
I have heard that testimony, yes.
And how long had you been up when you received that phone call on June 13th, 2020?
For more than 25 hours at that point.
How far away were you from downtown Atlanta and police headquarters at the time you were notified of the call?
I was more than an hour away by car.
Were you able to drive yourself at that point due to the fatigue?
No.
Did you have an opportunity to appear for the employee response session on June 13th, 2020?
No, I did not.
Did you want to appear to give an employee response session?
Yes, I did.
FURA leave has been discussed. Is FURA leave without pay?
No, it's not.
Do you understand it to just be an assignment?
Yes, it's an administrative assignment.
Are you personally aware of the time that passed between the presentation of the notice of proposed adverse action and the notice of final adverse action?
No, I'm not.
And the time that you were on FURA leave, were you permitted to be that far away from the center of the city?
Yes, I was.
Were you aware at that time that your face had been released, if not your name, but the video had been released to the media?
Yes, I was aware.
On June 13th, 2020 at 3:45 p.m., when you received a call, the first notice about the notice of proposed adverse action, did you believe it was safe for you to travel to the city of Atlanta to meet with anyone to provide an employee response session?
No, it was not safe.
Excuse me, I would like to object and move to strike all the previous testimony that does not go to background or experience. He doesn't get to pick and choose. If he's asserting his Fifth Amendment rights on the details of June 12th and the personnel actions that follow, then that's the Fifth Amendment right. It doesn't work this way where you get to assert some piece of it and then not assert it because your lawyer is the one asking the question. I believe the Fifth Amendment rights are being waived. And I
can respond.
I'd like Mr.
Please.
First of all, it does work that way. Second, all the questions I've asked are about June 13th, 2020, not June 12th, 2020. I have not asked a single question of this witness about June 12th, 2020, nor have I asked a single question about the events that led to the use of force. In addition, so far as the issue of the discipline, I have specifically stated at the outset that he would answer questions about his background or about his questions, which are the focus of this committee's hearing, whether or not once adverse action was proposed, whether it was done properly. That is the exact statement that I made when I said he would invoke the Fifth Amendment and the privilege regarding anything to do with the acts that occurred on June 12th, 2020.
I think the record is very clear and we move to strike. The chairman said very clearly background and experience, because that is what we heard you specify. You asked him whether he violated a work rule. That does not go to June 13th. So I move to strike.
Ms. LaRusso, I'm afraid she's right. Because you did ask a question about, sir, you did ask a question about the 12th and about a work rule. And so if he's asserting his right, he's asserting his right. And I believe Ms. Lawrence Hardy is correct on this point.
But he is able to select exactly what he wants to assert the Fifth on. That is black letter law in Georgia. I can give the court the cites. That is absolutely permissible in a criminal case or an administrative case or a civil case. I can give the court the cites right now.
Okay, but here's what I heard that I think runs afoul of him asserting the Fifth. There was a question, and we asked Ms. Fulgham to go back and read it for us, but there was a question about, did he violate any work rule with his actions on the 12th or something to that effect? Is that what you're talking about, Ms. Lawrence Hardy?
Yes, it is.
And so
well, we heard the objection.
That was in. Go ahead.
The objection, Your Honor, was that he was talking about more than background, and I specifically stated we would be talking about more than background. I said that at the outset, that he would talk about the discipline and that he would talk about his background and his employment. but nothing about the actual facts of what occurred. And he does get to pick and choose what he will assert the fifth on. It is for this board to decide whether it should be construed against him or what weight to carry with it. But he absolutely gets to choose which questions he asserts on. That is black letter law in Georgia. And I have the cites right here.
All right. But to the extent that you've asked him a question about violating a work rule on the 12th, you understand that Ms. Lawrence Hardy has a right to cross-examine him on that, right? Now that that's been introduced.
Or you can strike that answer, but if she cross-examines him on it, he has the right to plead the fifth. And if the court wants to strike that question and that answer, then that's appropriate. But the rest of that, the rest of the questions I asked had no difference, there's no differing whatsoever with what I said at the outset. And that's what my question, my concern was with Ms. Lawrence Hardy's questions. They were too broad. They were not sticking to his background or to the issues with the discipline. That was my concern at the outset.
Ms. Lawrence Hardy.
Under the law of Georgia, if a witness invokes the fifth, but then goes on to selectively answer questions about the same subject matter, the court can determine there's been a waiver. And I am so mindful of the time and of the complicated legal issues. I don't know if it's, and of the important constitutional issues here. I don't know if you'd like us to brief this or how you'd like to speak.
No, because as I said earlier, we don't have the authority to determine constitutional issues. I'm going to leave it right where it is. Mr. LaRusso, do you want to go forward asking your client questions? Ms. Lawrence Hardy's objection is on the record.
There are no further questions, and I was done at that point when the objection came.
How wonderful. Ms. Lawrence Hardy, do you have any cross questions?
I do. I have many now that we're talking about June the 12th. So I go back. Mr. Rolfe, you shot 3 bullets at Rayshard Brooks while he was running away from you on June the 12th and struck him twice, killing him. Is that correct?
Asked and answered. He's already asserted the privilege on that specific question.
I agree, Ms. Lawrence Hardy. What's your next question?
My question is, when you killed Mr. Rayshard Brooks, did you violate a work rule?
I wish to assert my rights under the Fifth Amendment to the United States Constitution, the Georgia Constitution, and state laws, and I won't answer that question.
And at this time, I move to strike all the testimony of Mr. Rolfe, and I move to dismiss his case pursuant to Savannah Associates versus Nashville and Gerala versus Pickett Street Hotel. He is the appellant, and it's one thing to plead the fifth, it's quite another to selectively plead it and answer some questions and not be willing to subject that same testimony to prosecution.
Ms. LaRusso?
Begner versus State Ethics Commission, 250 Georgia Appeals, 327, 2001. In addition, we have other case law. Dempsey versus Kaminsky Jewelry, 278 Georgia Appeals, 814, 2006. Hoffman versus U.S. 341 U.S. 479, 1951. A witness can selectively assert the fifth, and the body can decide whether or not a presumption would be against them. This is not a criminal case. If it was a criminal case, there would be a different standard. And so far as striking, if answers are to be struck in any fairness, it would be questions about the 12th if the court believes that I was treading over that boundary. The rest of his testimony had absolutely nothing to do with the 12th at all. It was related to the 13th, and it was related to the matters that specifically deal with the purview of this board. As you have said, the purview of this board does not extend to anything other than once an adverse action was contemplated, were the rules followed?
So at this point, ladies and gentlemen, we have run far afield of trying to get the appellant's case in. I understand your objections. Ms. Lawrence Hardy, if you have a question to ask of Mr. Rolfe on cross, please do so. You both understand I can't rule on these legal matters. This board is an administrative body. We are only here about the adverse employment action. And so at this point, Ms. Lawrence Hardy, do you have any other questions of Mr. Rolfe?
Mr. Rolfe, do you intend to invoke the Fifth Amendment after everything that's happened here today as a response to any question I ask about the events of June 12th, about the shooting of Rayshard Brooks, and about the process which led to your dismissal from the Atlanta Police Department effective June 14th?
Yes to all, except for the process that led to my dismissal.
So earlier when you told me you would assert the Fifth to that, that was incorrect.
I think that misrepresents his testimony, but we'd have to go back and look at it. I don't have time to do that. I just like the record.
Ms. Lawrence Hardy, what questions do you have of him?
You know, I'm going to, at this point, given I presume that I have about 3 minutes left, I'll save it for later.
All right. So anything, we're through with Mr. Rolfe, correct?
I just want to make, it sounds like it's denied. I just want to make sure I have a clean record that I have moved to strike and I've moved to dismiss.
I am not ruling on any of that. I don't have the authority to rule on any of that. And we're going forward. Mr. Rolfe, is he going to continue to testify, or do you have another witness, Mr. LaRusso?
No further witnesses. We rest. We're prepared for closing.
Closing arguments. Ms. Lawrence Hardy, you want to go first? You want to go last?
Last, please.
So it is 1:05 p.m. Mr. LaRusso, you have very few minutes more than Ms. Lawrence Hardy, but closings.
I'm sorry, I was twitching over. Tell me how much time I have. I'm sorry, but 1:15 is our hard stop, and I want to respect Ms. Lawrence Hardy's time as well. So
let's say she has 2 minutes and you have 8.
Okay. I do appreciate the board taking the time to listen to this case. And I want to point out a couple of things because we don't have a lot of time, and I want to respect your time. And I know your time is precious today. You have another hearing. We heard a couple of things that are very concerning. Number one, the notice of final adverse action and notice of proposed adverse action were given at the same time. Further, we've heard from Assistant Chief Coit that the only criticism he had, and it really wasn't even a criticism, more of a critique from the events that occurred, was that they should have moved Rayshard Brooks closer. He did not state that he had any other criticisms of the action of my client. In addition, I would quote Sergeant Dean, I don't know what else he could have done. I would point out to the board, these are the exact same situations that we saw with Gardner and Streeter. We saw no opportunity to respond to the allegations, and I would point back to opposing counsel's statement in her opening. It doesn't matter if it's 10 minutes or 2 minutes, the city gets to choose the amount of time they give someone to respond. That is not due process. The specifics of the disciplinary rules require that someone have an opportunity to prepare their response and an opportunity to appear. What we heard very clearly was due to safety concerns, due to an inability for him to drive, and due to the sheer amount of time. As we saw in Gardner and Streeter, there was no opportunity for Garrett Rolfe to provide an employee response session, and he did want to provide one. He didn't authorize anyone to do it on his behalf. And we also heard from Sergeant Dean that even if somebody was going to provide it on his behalf, Erica Shields and Todd Coit, the number 1 and number 2 in the police department, weren't even there. So there was no opportunity for him to give an employee response session. We've heard that there was no investigation done by Internal Affairs. And as we saw, he was never served with the notice of proposed adverse action. You heard from him that he's never even received it. And according to the rules, it's required that he personally receive it. And we heard a lot of testimony that if he receives it, he could reschedule the hearing. Well, first of all, we heard that there was going to be a press conference and there wasn't time to reschedule it. But second, he has to hold it in his hands to know that he has that right. So for the second time in 60 days, we have heard that the city of Atlanta did not follow their own procedures and ordinances in the termination of an employee. And when we go back and look at these over and over and over again, there's no reason for this. There's no reason to rush without an investigation. One of the things we heard was no firings with a shooting without an investigation prior to this date. You know, the 114-526 is an absolute red herring. When we hear this over and over again, we talk about being able to remove someone from the work environment. We've heard now from the assistant chief and from a internal affairs sergeant that there absolutely is a way to remove somebody under that code section without terminating them. And if you look at section 98-28, the police chief does have the power to hire and fire, but she absolutely must follow the rules and regulations of the city of Atlanta, the policies of the city of Atlanta, and the ordinance of the city of Atlanta. And that was not done. There is absolutely no reason, no justification whatsoever, and it is not due process to propose someone's termination, give them no opportunity to appear, and to say, well, as long as we give them 10 minutes to respond, we've checked the boxes. That's not what due process is. As the court said in violation of 114-532 in the Gardner and Streeter cases, the appellant was not given an opportunity to work pending the notice of final adverse action. That was found to be fatal in that case. In addition, as to 114-532, the appointing authority did not give a suspension with pay or without pay pending an investigation. It elected to terminate. And we heard a lot about the arrest. We heard a lot about the ability for him to come back to work. That is not a determination for this board. The determination for this board is whether or not his termination should be reversed. And we submit that it should be reversed. He should receive his back pay and he should be reinstated. If there are limitations on his working with the city of Atlanta, we heard that that can be accomplished within the guidelines of the city of Atlanta pending the outcome of the criminal investigation.
Thank you.
I'm just checking my notes. I'm trying to move as quickly as I can.
Sorry.
That's okay. I understand. I'm basically asking you to consider something. You had someone who is the valedictorian at 20 years old of the police academy, and then a couple of years later, he's valedictorian of one of the hardest academic classes in Georgia law enforcement. So he's one of the best and brightest of the city of Atlanta. Why would you push to fire him so quickly? Why wouldn't you do an investigation? If there's something wrong at the city of Atlanta that led to a work rule violation that's serious, a priority one complaint, why would you not do the investigation? And I think the short answer is, as Sergeant Dean said, there were parameters. He was told that he had to get this done. When we look at the rule of law, when we look at due process, we're trying to give people predictability that they know exactly what will happen when they're investigated. Following this case, we saw in the news 132 APD officers left the city of Atlanta. Shifts are short, patrol beats are not as effective, homicides are up. The bottom line is the city, instead of following the ordinances, turned its back on Officer Rolfe, violated its own laws, and claimed victory, while the people who live in Atlanta, who don't work behind metal detectors, access cards, and armed security, watch their streets and neighborhoods erupt into violence. I am asking you once again, as you have done in the past, if you look at Gardner and Streeter's opinions that you wrote, if you look at them, they mirror this case. They mirror this case. He was not given an opportunity to respond, and the city violated ordinance after ordinance. We're asking you to reinstate him, provide his back pay, and restore him to his full duty, and let the city of Atlanta decide if they want to do an investigation, or let the city of Atlanta decide what his role will be pending the outcome of these criminal charges. I thank all of you for your time.
Really, thank you now. Ms. Lawrence Hardy.
Thank you for your time. This is a hard case. This has been hard footage to watch, especially during this week in our country. And I appreciate the time and attention you've put into this discussion today. Our city today has the opportunity to be on the right side of history, where police officers are held accountable for their actions. We're not talking about criminal guilt today, of course. We're talking about termination from the job of police officer, reviewed under a much lower standard, of course, than a criminal trial. And indeed, as you said at the outset, Chairman Eves, the purpose of the board today is to review the adverse employment action and make a determination under the city code. We submit that under the city code, there are many grounds for which this board can uphold this dismissal. As an APD officer, appellant was to adhere to Atlanta Police Department work rules. And here, of course, the relevant rule is 4.2.5.0, prohibiting the use of unnecessary, or unreasonable force. And former Chief Shields had the authority to dismiss appellant based on his violation of the work rules. The board doesn't have to substitute its judgment for that of the chief, whose job it is to set the standard and ensure that the APD complies. You heard today from Sergeant Dean, who told you that the dismissal was procedurally correct. Because the dismissal was supported both in substance and procedure, the city asked that this board deny appellant's appeal and affirm his dismissal from the APD. Thank you.
Sorry. I remind everyone that this appeal is about the procedural enforcement of adverse action rules under the City of Atlanta rules. And I want to thank everybody for their time and attention. The hearing is now over at 1:06.